Mr. Traynor, I just want to follow up on my colleague's questions and make sure that I understand this. You were asked a series of questions about January 6th, and correct me if I'm wrong because I was not here at the time you were asked those questions, and you declined to go into whether this was an insurrection, the nature of the attack on the Capitol, because you said it might involve a case or controversy that would come before you. Is that correct?
Senator, it did involve cases or controversies. We had people in the District of North Dakota that I believe were charged.
So you felt it wouldn't be appropriate for you here today to discuss your views on what took place on January 6th, is that right?
I stated that what I saw was deeply troubling, Senator. The attacks on law enforcement, any attack on law enforcement should be condemned.
So why are you reluctant to answer questions about what took place on January 6th? On the one hand, and on the other hand, you say judges don't forfeit their First Amendment rights. You feel free to write to a university to tell them who they should hire or not hire, who you're going to hire or not hire. You feel free to immerse yourself in that controversy. But here you won't talk about your views of January 6th. Can you reconcile that for me?
Yes, the difference, Senator, is that there is no case or controversy with regard to hiring of law clerks, but handling matters.
Well, you're saying there's no case or controversy involving Columbia, involving the efforts by the administration to punish Columbia, all the litigation around Columbia. That wasn't the case or controversy?
That was far afield from the letter that was signed, Senator.
Really? Why is it far afield? Weren't you complaining about what was taking place on the Columbia campus, and as a result that you weren't going to hire law clerks and the other judges on your letter weren't going to hire law clerks? Wasn't that the nature of your correspondence?
Yes, that was the nature of the correspondence.
So you feel perfectly free to immerse yourself in that, exercise your First Amendment rights there. But when it comes to asking you basic questions about January 6th, you won't answer those questions.
The difference, Senator, is that there are cases or controversies that I have before me as a district judge relating to individuals that have been charged for conduct that occurred on that date in this Capitol.
So does that mean that any litigation involving Columbia you're prepared to recuse yourself from?
Senator, the limitation on Columbia was in regard to hiring law clerks. I hold no bias against the institution itself.
Well, whether you hold a bias towards it or not, you're saying today that you can't discuss any of the January 6th stuff because there are pending cases or controversies, even though they've all been pardoned by the president. I'm not sure what case or controversy you're referring to, but nevertheless, you're unwilling to say you recuse yourself from a case or controversy involving Columbia when you specifically weighed in there. How do we reconcile that?
Well, Senator, as I stated in the recusal order that Ranking Member Durbin raised, I indicated that I held no particular bias against.
Well, yeah, that's fine. You can say you hold no particular bias about January 6th, too. I mean, it's easy to say. Your letter demonstrates a very clear bias. I'm not saying that it's an unreasonable bias, but it is a bias. It is a prejudice in favor of one view that would cause people to question your impartiality if that case came before you. That seems to me a stronger, much stronger case for recusal than the one you're making to refuse to answer questions about January 6th. So let me just ask to make sure that I understand the limits of what you're prepared to say. Who won the 2020 election?
Senator, as I indicated in response to questions from Senator Blumenthal, Justice Ketanji Brown Jackson, as a sitting circuit court judge at the time of her nomination, was asked this question in questions to the record.
I'm asking you the question.
Yes, and as a sitting judge, I will tell you that it is not appropriate for a judicial nominee to engage in discussion regarding a matter of political controversy with that.
See, this is completely inconsistent with your involvement in the whole Columbia controversy. Completely inconsistent. Because you involved yourself in that controversy. You went out of your way. Nobody asked you to write that letter. You took this upon yourself to do, to insert yourself into that. But you're saying here, you can't answer a simple question about who won the 2020 election because it would somehow implicate you in controversy. I'm sorry, there's no way to square those two things. Mr. Chairman, I yield back. I just wanted to add on to what Senator Whitehouse was saying. In the Central District of California, we have no U.S. attorney. We have no acting U.S. attorney because the person who was acting, their tenure expired. And to get around the confirmation requirement, they have been made the first assistant U.S. attorney and are presumptively running the office from that post. This is someone who has demonstrated their unfitness for the job by going into grand jury so often. His name is Bill Asaley, and getting a no bill, that is the grand jury refusing an indictment when the bar is only probable cause, that they have taken to calling him No Bill Asaley. It was reported in the LA Times that he was heard shouting at the Justice Department over the phone within earshot of the grand jury, vis-a-vis the Justice Manual's requirement that you don't seek an indictment unless you believe you can prove beyond a reasonable doubt someone's guilt at trial, shouting at the Justice Department over the phone that they can F the Justice Manual. And this is who's left in charge of this office, this very important office. So I just want to acknowledge the concern that Senator Whitehouse raised, and because we're seeing very much the same problem in California. Thank you, Mr. Chairman.
The hearing erupted into a sharp confrontation over judicial independence, political bias, and accountability. Senators questioned a federal judicial nominee about what they viewed as a glaring contradiction in his conduct. On one hand, the nominee claimed he could not answer basic questions about January 6 or the 2020 presidential election, because those topics could involve cases or controversies that might come before him as a judge. On the other hand, he had willingly involved himself in the highly publicized controversy surrounding Columbia University by signing a letter criticizing the institution and announcing that he would not hire law clerks from there. Critics argued that this position was impossible to reconcile. They pointed out that the nominee was perfectly comfortable using his First Amendment rights to publicly weigh in on a politically charged debate involving a major university, yet suddenly became reluctant when asked straightforward questions about one of the most significant events in modern American political history. Senators repeatedly pressed him, asking why he could openly participate in one controversy while refusing to discuss another. The most intense exchange centered on January 6. The nominee acknowledged that what he witnessed was deeply troubling and condemned attacks on law enforcement, but he stopped short of offering a broader assessment of the attack on the U.S. Capitol. He argued that ongoing legal matters connected to January 6 required him to remain cautious. His critics were unconvinced, noting that he appeared willing to comment on controversial public issues whenever he chose but invoked judicial restraint only when the questions became politically sensitive. The hearing escalated further when senators asked a simple question: who won the 2020 presidential election? Rather than giving a direct answer, the nominee stated that it would be inappropriate for a judicial nominee to engage in discussions involving political controversies. This response sparked immediate criticism. Senators argued that acknowledging the certified outcome of an election should not be controversial, and accused the nominee of avoiding a basic factual question. Throughout the exchange, senators suggested that his actions created the appearance of selective neutrality. They argued that judges must not only be impartial, but also appear impartial to the public. By publicly involving himself in disputes like the Columbia University controversy, while refusing to address fundamental questions about democracy and the rule of law, they claimed he was undermining confidence in his own objectivity. The discussion then broadened into concerns about the Justice Department itself. Lawmakers raised alarms about leadership issues within federal prosecutors' offices, particularly in California, where they argued that temporary appointments and procedural maneuvers were being used to avoid normal Senate confirmation processes. Specific criticism was directed at an acting federal prosecutor, whose record before grand juries was described as deeply troubling by opponents. By the end of the hearing, the central issue remained unresolved: supporters of the nominee defended his caution as appropriate judicial restraint, arguing that judges should avoid commenting on matters that could come before the courts. Opponents countered that his selective silence revealed a double standard. One that allowed him to engage in political controversies, when convenient, while avoiding direct answers on issues of national importance. Ultimately, the hearing became less about legal qualifications and more about trust, impartiality, and whether Americans can have confidence that judges will apply the law fairly, regardless of politics. The exchange highlighted the growing tension between judicial independence and public accountability. In an increasingly polarized political environment,